So good morning, ladies and gentlemen, and our distinguished guests. Thank you for coming here to ASPI this morning. I'd like to welcome you all for what looks to be a great day. My name is Liam Neville. I'm the Principal Analyst at the International Cyber Policy Centre here at ASPI, and we're very pleased to be co-hosting the Australian launch of the Tallinn Manual with the Dutch Embassy and the NATO Cooperative Cyber Defence Centre of Excellence, and I'd like to thank them for their support today. I'll just quickly take you through our program for this morning, and then I'll hand over to our experts. So after me, we'll have some welcome remarks from the Netherlands Ambassador, Her Excellency Erika Schouten, and then we'll have Ms. Lies Verhoel from NATO CCDCOE, I'm going to get that right one day, who will provide us with a quick overview of how the manual was developed, and then we'll have our expert panellists come onto the stage. So this morning, very happy to have Professor Mike Schmidt, the Director of the Tallinn Manual, Professor Tim McCormick from the Melbourne Law School, and Associate Professor Rob McLaughlin from ANU to discuss the manual, and then we'll have some questions from the audience, and then we'd also like to invite you to have some morning tea in the lobby afterwards. So I'm sure, like me, you're looking forward to a great discussion about this really influential resource for legal and policy communities. So to get the show on the road, please join me in welcoming the Netherlands Ambassador, Erika Schouten, to the podium. Thank you.
So good morning, ladies and gentlemen. And thank you for that introduction, Liam. It's wonderful to be here, and it's a good turnout. Thanks to ASPI for organizing, and to all the distinguished speakers for their contribution that they will give later on. It's very fitting to launch a manual named after Tallinn, the capital of Estonia, today, because as you may well know, today is Estonia's National Day. It's marking Estonia's Declaration of Independence in 1918. Unfortunately, my colleague Ambassador Anders Unga is not here, but I promised to mention Estonia's National Day here, so you are witnesses to that. But Lies Verhoel is here from the center in Tallinn, but also an Estonian national. So congratulations on your national. Well, the manual is named after Tallinn because it's the seat of the NATO Cooperative Cyber Defence Centre of Excellence. I won't even try the abbreviation, but that is for a reason. In 2007, Estonia faced cyber attacks that have been widely acknowledged as the world's first cyber war. And at the peak of these attacks, 58 Estonian websites were offline at once, including those of the government, most newspapers and banks. These cyber attacks brought the attention of the international community to cybersecurity. And Estonia is at the forefront of the digitalization of society and wants to protect its e-government and IT infrastructure system. And this is why Estonia has invested heavily in cybersecurity infrastructure. So that explains the Tallinn part of the title of today's conference, but what has the Netherlands to do with it? Well, the Netherlands has a special involvement with the Tallinn Manual 2.1 for two reasons. First, this manual deals with the question how existing international law applies to cyberspace. And international law, as you may well know, in the Netherlands is just our cup of tea. In early 2015 and 16, the authors of the manual and legal advisors from over 50 states and international organizations, representing all continents, convened in 3 sessions in The Hague to consult on the Tallinn Manual 2.1. And these consultations were called after the city in which they were held, The Hague, so The Hague process. The Hague, by some called the legal capital of the world, or as we say it in the Netherlands, the international capital for peace and justice, provided a perfect backdrop for this. The Hague is home to 160 international organizations dedicated to promoting justice, peace, and stability. The most well-known of these organizations, of course, is the International Court of Justice, but there are many others, and to name just a few, the Permanent Court of Arbitration and the International Criminal Court. The second reason for the Dutch involvement with the Tallinn Manual is the importance we attach to cyber issues. We see cyber attacks as the key threats of the future, as they target countries, individuals, companies, and infrastructure networks. And we think the world is still too passive about this issue. We also have a special interest as a country, as the Netherlands is the world's largest internet hub and is home to Europe's most ICT-intensive economies. And as my foreign minister, Minister Geert Koenders, said last week, in cyberspace, major Dutch interests are at stake. There are huge opportunities for economic growth and development, but also increasing threats. And our infrastructure is becoming ever more dependent on the internet, so clarity on international standards is a matter of national importance. He said that in Munich, at the Munich Security Conference, where he launched the Global Commission on the Stability of Cyberspace. And this commission will bring together 24 prominent independent experts from 15 countries, representing the public sector, the business community, and the IT sector. And members of the commission will draw on their expertise to propose standards for conduct in cyberspace. The commission will receive support from several parties, including Microsoft, and organizations active in the field such as the Internet Society. The commission will be based in The Hague and will be chaired by former Foreign Minister of Estonia, Marina Kaljurand. I can give you more examples to illustrate our keen interest in and our leading role on cyber issues, ranging from the Hague Security Delta to the recently established Cyber Security Academy in The Hague. But I think that's maybe topic for another discussion and not for today. But I think you now get the picture why Tallinn and why the Netherlands. So back to the manual itself for some final words. Minister Koenders, the Foreign Minister of the Netherlands, wrote the foreword to the manual where he said, "The threat posed by cyber attacks and disinformation has only grown in the past few years. The Tallinn Manual 2.1 is an indispensable guide to a largely unexplored new field. Many rules date back to the pre-digital age, but malicious hackers and the wide dissemination of fake news are now a daily reality. We desperately need clarity about the rules so that action can be taken. And it's for this reason that the Dutch Ministry of Foreign Affairs is currently promoting the Tallinn Manual 2.10, sorry, I'm already into the next edition, by organizing launches of the manual worldwide. We have had similar launches in Washington, in The Hague, in Tallinn, and today in Canberra. The 2017 edition covers a full spectrum of international law applicable to cyber operations, ranging from peacetime legal regimes to the law of armed conflict. Some pertain to general international law matters, such as the principle of sovereignty and the various bases for the exercise of jurisdiction. Australia has been involved with the Tallinn Manual process from the very beginning, together with countries like the Netherlands, US, Canada, Estonia, other European countries. However, the first manual has received criticism for lacking global representation. And therefore, I'm happy to report that for the second version of the manual, the engagement with the international community has been very wide. For the Tallinn Manual 2.0, there was a strong participation of Asia-Pacific countries, including Australia, but also China, India, Japan, Pakistan, the Philippines, South Korea, Sri Lanka, and Thailand. And rightly so, because a safe and secure cyber domain is in the interest of us all. I will leave it at that in order for the real experts to have their say. I'd like to thank ASPI once again for helping us to organize this event, and I'd like to thank you all for being here today. Thank you.
Good morning. Thank you as well from my side, Ambassador, and good morning to all of you, ladies and gentlemen. It truly, for us at the NATO CCD COE, is a privilege and an honor to be not only launching the Tallinn Manual 2.0 in the NATO space, but also beyond the North Atlantic Treaty Organization, for the obvious reason that international law is global and applies to states globally. And the Tallinn Manual, despite the fact that it carries the name NATO on its cover, is not a NATO document or reflective of NATO policy, but indeed an attempt to objectively and accurately restate customary international law as it applies to cyber activities. But what I'd like to do over the next few minutes is to give you a brief overview of the Tallinn Manual, why it was written, and for whom it is primarily meant to be used. And to do that, I will, of course, have to go back to the cyber attacks that occurred against Estonia in 2007. As the ambassador mentioned, the 2007 cyber operations did not only direct the international community's attention to cyberspace and cyber operations as a new threat to national security. But moreover, those cyber operations conveyed the message to the international community that new and interesting and complicated legal questions arise when we look at what happened in 2007. And this reality was even more confirmed in the following year in the armed conflict between the Russian Federation and Georgia, where cyber operations were a major part of the conflict. And at that point, it was clear that cyber operations are here to stay, and it is for the legal community and for states to come up with answers as to how international law applies to those incidents that the international community had witnessed in the 2 years. And to start answering those questions, we at the NATO CCD COE convened an international group of 20 scholars and practitioners. And their task for the next 3 years was to look at some areas of international law as they apply to cyber operations. When the NATO CCD COE tasked the international group of experts to start looking at the associated legal issues and to produce a manual on those, we weren't actually stepping on completely new ground, because international law has a fairly long tradition of producing international law manuals. And as you can see, this tradition goes back to the late 19th century. And in the last couple of decades, there have been a number of manuals that have been produced. And after the Tallinn manual, you can see that a new project has been launched that looks at how international law applies to military operations in outer space. So manuals for sure have a place in the international legal community. Now, this was the first Tallinn manual that was published by Cambridge University Press in 2003. And the first Tallinn manual looked at the so-called high-risk, low-probability cyber events. In other words, those that are less likely to occur, but once they do occur, they present the highest risk to national security. And therefore, from a strategic perspective, it was most important to look at the law governing those types of cyber operations first. More specifically, the first Tallinn manual looks at two bodies of international law. The first is the Jus ad bellum, the law that is reflected in the UN Charter primarily. And cyber operations that fall within the UN Charter paradigm, fortunately the international community has not witnessed too many of them. There are only a few that I would say raise questions under the Jus ad bellum, most notably the Saudi Aramco incident from a few years ago, as well as the Stuxnet operation. And then secondly, the first Tallinn manual looked at those cyber operations that occurred during armed conflict. In other words, those that are a part of modern warfare. And it has been clear since 2008 that cyber operations indeed are a part of modern warfare. And this has been confirmed by all the subsequent conflicts that we have witnessed. And even today we know that the United States, for instance, is conducting cyber operations in the armed conflict that is underway against Islamic State. So that was the first Tallinn manual. However, at the NATO CCD COE and among the international group of experts, we were acutely aware of the fact that on a day-to-day basis, states are not grappling with questions as to how the Jus ad bellum and how the law of armed conflict apply to cyber operations, because most cyber incidents fall below those levels. And so we undertook this new journey to produce the second Tallinn manual. Unfortunately, we don't have the book here today because you guys are so far away that the book shipment is probably on a big cargo ship on its way to Australia right now. But this is what the book looks like. And these are the types of issues that the second Tallinn manual addresses. So, of course, we looked at the issue of cyber espionage. We looked at how customary international law governs cyber espionage. We looked at cyber sabotage, if you will, the Sony hack type of incident when computers are impacted in a way that hard drives are wiped, for instance, but the consequences are not severe enough to characterize the incidents as uses of force, for example. Then we looked at, of course, issues of influencing states' affairs through cyber operations. a reality that the United States recently experienced. And then we also looked at, as was mentioned, how, for instance, the principles of jurisdiction apply to cyberspace. For instance, when state law enforcement authorities attempt to battle transnational botnets and they try to take action against botnet infrastructure that is located abroad, what does the law say about those types of cyber operations? A couple of words about the process. The first Tallinn manual, as I was mentioned, the project was kicked off in 2009, so it has been a fairly long journey for us at the CCD COE. We've been doing this for almost 8 years. The two projects, the two different legal parts, were written by two separate international groups of experts. Some of the experts were the same in both groups, others were new because the legal areas that we looked at were different, so we also included some other experts. All the experts participated in their private capacity, which means that the manual indeed, not only is it not reflective of NATO policy or NATO doctrine, neither is it reflective of the state policies of any of those states from where we had experts participate in this project. And the primary target audience for the Tallinn manual are state legal advisors. In other words, an attorney at the Ministry of Foreign Affairs or an attorney at the Defense Forces or Ministry of Defense who one day gets the cyber portfolio or whose boss one day steps into the office and says, this is what's going on, what can we do, how can we respond, how can we defend ourselves. So it's primarily state legal advisors for whom we wrote the book, but of course, as we've already seen, not only state officials but also academics seem to take quite a bit of interest in it. Now, the whole premise of the exercise was to interpret existing international law, the pre-cyber international law, in the context of this new security situation. In other words, I mentioned the UN Charter, but moreover, all of the legal areas that we discussed, the law of state responsibility, diplomatic and consular law, all of those norms and principles existed before cyber became an issue for states. And the premise of this exercise is to see how this pre-cyber international law applies to the cyber operations that states are experiencing. The book is set up in the form of rules and commentary. There are 154 rules in the second Tallinn manual. Once you get the book, you'll see that it's much bigger than the first book. The reason is that we reprinted the first Tallinn manual's analysis in the second book. So in other words, the second book replaces the first edition, and we recommend that you use the second edition instead of the first one from now on. So there are 154 rules, and each rule has a comprehensive commentary explaining then how this broad black letter rule is to be understood and applied. And finally, as was mentioned, we received lots of very important external input to this process. We had a rigorous peer review. We had over 50 peer reviewers from all over the world, some of whom are in this room today. And moreover, we also received input from states through the Hague process. And indeed, the Hague process was crucial for us because, as I mentioned, the book is written primarily for state legal advisors, which means that state legal advisors are more likely to use the Tallinn manual if their state has not got a hostile attitude towards the Tallinn manual or believes that it is a good product. And the Dutch Ministry of Foreign Affairs really has helped us achieve some buy-in from states all over the world to the Tallinn manual, for which we're very grateful. These are the contents of the second Tallinn manual, all the way up until here. This is the second Tallinn manual's material, and I think the main takeaway from this is that there is a lot of international law that applies to cyber operations. In other words, just because cyber is new, if you will, it does not mean that we by definition need new international law to govern it. These are the international law regimes that we concluded were most relevant in the cyber context, and so there are chapters on each of those. And then these last four are the Tallinn 1 chapters that, like I mentioned, we reprinted in this new book. And with that, I will hand it over to the panel. I think I should say, with regard to the NATO CCD COE, because we are right now outside of the NATO space, we are not a part of NATO. but instead we are one of NATO's 24 centers of excellence, which are separate international organizations that work for NATO. And the CCD-COE in Tallinn is the biggest center of excellence. Today we've got 17 member states out of NATO's 28. Plus we have 3 contributing participants, in other words, states that work closely with NATO but are not NATO member states. And I believe it is the case that Australia is closely looking into this option of becoming a contributing participant to the CCD-COE as well. But with that, I really will hand it over to the panel, so I thank you for your attention.
I don't know why you're not up here. You should be up here.
You're smarter than him.
Way smarter.
Well, ladies and gentlemen, we've had a wonderful introduction to the reasons why Tallinn 1 and Tallinn 2 exist, to the purpose behind Tallinn Manual, and to the processes thus far for developing the Tallinn Manuals by Her Excellency the Ambassador and by Lise. So what we will use that baseline for now is to perhaps explore some of the more detailed issues that arise in Tallinn, but also in the world of cyber more generally. And to that end, we have an excellent panel of 2 experts. I'll briefly introduce them. Professor Mike Schmidt is the Professor of International Law at Exeter University and also the Chairman of the Stockton Centre at the US Naval War College. He had a former career as a US Air Force Judge Advocate General and is accepted by, I think, anyone who knows anything about this area as one of the world's foremost experts on the law of armed conflict, and certainly through the Tallinn process, tells me he now knows how to turn a computer on, so that's a great advance.
Fantastic.
We also have, of course, Professor Tim McCormack, who's the Professor of International Law at the University of Melbourne and is also one of that handful of world experts on the law of armed conflict and has had a number of very prestigious appointments, including as a special advisor to the prosecutor at the ICC and as a noted expert, not just on the law of armed conflict, but on ICL. So you have a very good field of people to pick brains from at the moment. So the process we'll take is that I will simply ask a lead-in question of both of our panellists, and then I will throw it open to you. As we do that, could I ask if you have a question, and many of you will, or a point of discussion, 3 things. 1, could you wait until the microphone gets to you, just so that we can all hear? I'm as deaf as a post, I don't know about these 2, but it'd be useful to be able to hear the questions. 2nd, could you just explain briefly your name and your affiliation? And then 3rd, please ask your question or make your point in as concise a fashion as possible, so we have plenty of opportunity for everyone to have their say. So with no further ado, I'll start with you, Mike, and could you briefly outline perhaps what some of the more contentious issues you faced between dealing with Tallinn 1 and Tallinn 2? What were some of those issues that were really quite difficult to massage your way through in order to reach an outcome in Tallinn 2?
So in Tallinn 1, we anticipated that the most contentious issues would be the red line where you have a use of force and the red line where you have an armed attack that gives a state a right to act in self-defense. It turned out that those were not the most contentious issues that came out of Tallinn 1. There were 2 contentious issues. One was, what's the meaning of the word attack in international humanitarian law? And the reason is so many of the prohibitions on humanitarian law are framed in terms of the word attack. You may not directly attack civilians, you may not directly attack civilian objects, and on and on and on. So that was it was difficult to understand what that term meant in the purely cyber context when you're not causing physical damage or you're not injuring people. So that's proved fairly contentious. We took a somewhat liberal approach that said that if you are affecting the functionality of an object, cyber infrastructure, then that was an attack. The second contentious issue, and it remains a very contentious issue, was also a terminological issue, and it had to do with the word object. And the question that we struggled with, and the reason object is important, is you may not directly attack a civilian object. So the question was, is data a civilian object such that there's a prohibition on attacking data. Well, I'm not sure we got it right because there was no good answer. If you prohibit the attack on data, then you're going to prohibit lots of operations that states have already engaged in, so it's over-inclusive. And if you don't prohibit the attack on data, then you're going to allow operations during an armed conflict that can really impact the civilian population in a very negative way. So those are the two issues that, as Tallinn 1 was published and people started looking at it, those are the two issues that raised eyebrows. Now, with regard to Tallinn 2, there were probably three issues. The first was due diligence. Due diligence is a principle that says a state must take action to stop harmful activities from its state vis-a-vis other states. So in state A, there are harmful activities that affect state B. State A has an obligation to put an end to those activities. In the cyber context, when we met with states at the invitation of the Hague, or of the Dutch Ministry of Foreign Affairs, states were very nervous that we had applied this principle to cyber. Yes, of course, it applies to environmental harm and things like that. But cyber, they were nervous because they felt that if this was in fact a legal obligation, that this was an enormous legal obligation, a really weighty legal obligation, because every single day here in Australia, there are lots and lots and lots of harmful cyber operations being launched across borders. But what we explained to states was that the obligation is only one of feasibility and reasonableness. In other words, you don't have to do everything you possibly can. You have to do what would be feasible in the specific circumstances, and the obligation only applied when the cyber operation was causing adverse consequences that were serious in another state. So it's not everything. It's really, really bad stuff, and you only have to do what's reasonable in the circumstance. And I would hope that the Australians are already doing that. I know certainly in my country we do that at any rate. So that was contentious, but some of the brouhaha has died down after we went to The Hague on 3 occasions and explained our thinking. The second issue that became a little bit controversial after we had completed our work and after we had met with 50 states and after we had peer reviewed with 50 scholars around the world is sovereignty. Because very recently, the U.S. Department of Defense's legal advisor, on the day before she stepped down as a result of the new administration, issued guidance to all the combatant commands and to all the judge advocate generals of all the services that said that sovereignty was not a primary norm of international law. Now that's academic blah blah. Let me explain. So a primary norm of international law is like a rule. So a state violates sovereignty, which is unlawful under international law. And the legal advisor opined, in my view incorrectly, opined that it wasn't a rule, it was just a foundational principle that real rules came out of, like non-intervention or the prohibition on the use of force. That is, at the moment, simply a DoD General Counsel position. I'm not sure everyone in the U.S. government agrees with it. Certainly none of the experts agreed with it, at least at the time that we were doing the project. We had not heard noise about this before, but I anticipate that those of you who work in government are going to be hearing a lot about it. And the reason it's important is because in international law, sometimes what you see depends on where you stand. So if you are an organization that engages in offensive, and I'm not meaning unlawful or bad, I mean offensive operations, you're launching across borders, what you want is you want your normative firewalls to be low. In other words, you don't want the law to hinder your operations. So you would not like a rule that says if you conduct operations into another state with certain consequences, that's a violation of international law, so you may not do that. By contrast, if you represent an organization here in the room today and your job is to defend Australian cyberspace, what do you want? You want a normative firewall that's very high so that international law facilitates your operations so you can name and shame other states that have conducted operations against you. So this wasn't controversial during the manual. In fact, the same rule in a very abbreviated form appeared in Tallinn 1, but for some reason it has become controversial now. And then finally, the last one is, and I'll leave this to Q&A, is the principle of non-intervention. One state may not intervene in the internal affairs of another state. And I forgot to mention that I work for the Department of Defense, but my views, as you clearly have determined by now, do not necessarily represent the views of the Department of Defense or the Department of the Navy or anyone else I might work for. The Democratic National Committee hacks by the Russians have caused everyone to start looking at the principle of non-intervention and ask whether the activities of one state in cyberspace that interfere in the elections of another country is unlawful, has a violation of the principle, and I can explain it in Q&A. I've just written an editorial in the Times that says it is. Okay, so those are Rob, the big issues that are controversial right now.
So we'll come back to those. I'm sure there'll be some questions from the audience, and we'll explore some of those a bit more deeply. So to bring it to a local context, Tim.
Yeah.
Do you have some views on what Tallinn and this whole area of law means for Australia now?
Yeah, I do. Like to share?
Please do.
Perhaps just a couple of prefatory comments about Estonia's National Day, if I could. If you could just indulge me on that. So we have a second Estonian in the room. That's an unusual experience in Australia. So Lisa and Ryan can have a little chat in their own language if they'd like to celebrate and mark this day. But I also just want to acknowledge that Mike he's just been gonged, the equivalent of the Australian Honours by the government of Estonia. Unfortunately, he was not able to collect his award in person, which should have happened yesterday, the day before the National Day, because being the dutiful person that he's in Australia for the fourth launch of Tallinn 2.0. So congratulations to you, and a cavalier, no less.
Yes. Anyone can be a knight, but a cavalier, now that's something. Okay.
in the order of Estonia, congratulations. I think that's really wonderful news. And it's important that we acknowledge it. And I would also just like to say on the subject of Estonia that for me, the privilege of being a member of the International Group of Experts and being hosted by Lise and her colleagues 4 times in Tallinn was truly outstanding. I got very, very fond memories of the time we spent together and the hospitality that you showed us. So thanks heaps, Lise. It was an honour and a privilege for me. So yes, to Australia, we haven't here been the subject of cyber warfare. We'd all know it if we had been. And that's something to be very grateful for. And of course, it's not something to be blasé about. And I'm sure our cyber security and cyber defence agencies are working hard to prepare for the possibility of it and to minimise the risk of it. But because that's the reality, then Tallinn 2.0 is more relevant to us, I think, on a daily basis in the national context than Tallinn 1.0. I should say that we'll qualify that statement by the observation that, of course, well, not of course, I assume that the ADF in the operations that we've been engaged in Afghanistan and currently engaged in Iraq and Syria are engaged in cyber operations and are probably the subject of cyber operations. And to the extent that that's happening in the context of those respective armed conflicts, then Tallinn 1.0 and the rules about those aspects of the law of international armed conflict that apply, or the law of non-international armed conflict that apply, are directly relevant to Australia. But in terms of our national experience, I think the content of Tallinn 2.0 is more relevant, and Lee's explained exactly why that's the case. So I have no inside information. I'm not disclosing confidentialities in terms of what's been in the press, what's been covered in Australia, things like the hack into the Bureau of Meteorology or the possible theft of the blueprint of ASIO's new headquarters. Those are below the threshold of armed conflict, and so the relevant rules that apply to how we characterise what's happened and how we are entitled to respond to international law are covered by the material in Tallinn 2.0. For lawyers, and I really want to say thanks to ASPI for indulging us with the opportunity an exclusive legal panel up here. Not that you're illegals, but rather than extra legal aspects of the issue. Tallinn terminology is a really big deal for us. So when we hear language like a cyber attack or cyber warfare, there's part of us that bristles against that. So I had the privilege of spending 12 months with Mike at the Stockton Centre at the Naval War College in Newport, Rhode Island. And just before I left Australia for that wonderful experience, the Sony hack had occurred, and so had the theft of the personal details of 21.5 million US civil servants in the attack on the OPM, the Office of Personnel Management. And the media coverage about those hacks was in many cases hyperbolic. This is the equivalent of the US's cyber Pearl Harbor. This is war. The president needs to understand that, needs to respond accordingly. International lawyers, well, I certainly react against that. No, that's not. I can understand from a popular sort of sense why you want to talk about attack or why you want to talk about warfare, but these, as Mike has suggested, these terms are terms of art in international law, and by any measure under the law applicable to attacks and to the threshold for a legitimate response with lethal military force to an attack against a state, these acts and events do not qualify. So for us, we also place big emphasis on a term like norm. When we as international lawyers talk about a norm, we are talking about a binding rule of customary international law, whereas in a popular sense, you're talking about norms as in what's acceptable behaviour by corporations in response to cyber operations directed against them. So, yeah, I mean, there will always be issues for us, I think, about how terms are used, but hopefully some of the content of Tallinn 2.0 will help both governments, corporations, and others interested understand the legal framework that's applicable and how it might be used to justify certain responses, to cyber operations directed against them.
Thanks, Tim.
Thanks, Rob.
There's a host of questions and issues, obviously, that have just popped up then from Mike and Tim's very short introductory comments. So at this point, we'd like to throw it open to the audience for any questions. We'll start here. As I said, please just wait for the microphone and just let us know who you are, where you're from, and then what you've got to ask.
Thank you. David Fricker from the National Archives of Australia. I'm very interested in protecting Australia's information assets from cyber attacks. Just following that last discussion, and it's a stupid question because I understand nothing about the laws of warfare, but it seems to me with cyber war, one of the things that characterises it is that this degree of uncertainty about who is the perpetrator. And just to your comments about proportionate retaliation or defence, how has that been dealt with here, where it's the nature of cyber is there's always this uncertainty about who's the perpetrator, and therefore how do you decide on what is a proportionate defence or even offensive action in defence, and to what extent does that sort of move from cyber into more traditional theatres of war? So can you retaliate with, bombs and more sort of traditional? Is that dealt with in the, and how is it dealt with? I'm just interested in that discussion.
Mike, do you want to take that? Then we'll go to Tim.
So we must distinguish factual attribution from legal attribution. There's an entire body of law called the Law of State Responsibility that deals with legal attribution. The question most often asked there, when is the state clearly a state's responsible for any action taken by defense, for example. But when is the state responsible for the activities of non-state actors? But the answer is when the state instructs, directs, or controls the actions of the non-state actors. And those are very complicated terms, but that's the most often asked legal question. Now, with regard to your question, which is about factual attribution, there's actually a pretty easy answer, okay? And it's that states must act as reasonable states would in same or similar circumstances. So it isn't that if Australia chooses to attribute an action to a state and that attribution is wrong, Australia has in no way violated international law, because states aren't obligated to act correctly every time. They're obligated to attribute reasonably. So I know that's a completely unsatisfactory answer to you, but that's the legal standard of reasonableness. There is a slight but. If Australia wishes to respond to an unlawful cyber operation directed against it with a cyber operation that itself would be unlawful, that's called a countermeasure, but for the fact that it's a response, then Australia must not only be reasonable, but Australia must be correct. So let me give you an example. State A conducts an intervention into the internal affairs of State B. I'm sorry. An action occurs that is perceived has an unlawful intervention in the internal affairs, and it's perceived so incorrectly. So the other state says, you know what I want to do? I want to hack back. I want to hack back as a form of countermeasure designed to get the state I believe is responsible to knock it off. But it turns out
to stop their behaviour.
to stop their behavior.
Yeah, knock it off you can interpret it different ways. I know what you mean.
Okay.
He's
Just
American.
clarify. Stop their
So if
behaviour.
we're being recorded, I apologize. If you could roll the film back, please.
Second Amendment, knock it off.
So,
far out.
okay.
Jeez.
So to get the other side to terminate their unlawful activity, that's what the purpose of a countermeasure is. But they got attribution wrong, then the state which responded, the state which misattributed, will itself have engaged in an unlawful action. But that's the only case in international law. I'm overstating the singularity, but it's the case in international law where it's not just reasonableness, but you have to be right. The classic example here is, of course, Iraq. I mean, when we engaged in operations against Iraq, there's complicated legal reason why we engaged, but remember that we were attributing weapons of mass destruction activity, and we were attributing ties to transnational terrorism to Iraq. It turned out that wasn't the case. We never found those weapons and so forth. People wanted to say, and therefore your action was unlawful. The correct answer is no, that's not correct at all. The question was whether or not our attribution was reasonable, and I can go through an entire argument on why it was reasonable, and thus there was no violation of international law. Same here, except for that narrow countermeasures case.
Tim?
Attribution, factual attribution, of course, is can be technically complicated, and I think it's really important, as Mike said, to distinguish between legal attribution and factual attribution. But the reality that in relation to certain operations, to trace back to be able to, with confidence, identify who is responsible, doesn't change the legal framework and the applicable legal rules. If you're going to take countermeasures, and I'd say on the subject of countermeasures, which we deal with extensively in Tallinn 2.0, and I think it's an understudied area of international law, not only in relation to cyber operations, but we deal a fair bit with that. If you're going to undertake countermeasures, you better know what you're doing. I was really surprised a few years ago when the Department of Justice in the United States issued arrest warrants against 5 named Chinese nationals in the particular cyber offensive unit of the People's Army. And I thought there must be some real certainty about that, because why would you name the individuals in arrest warrants wanted for trial in the United States for their involvement in, I can't even remember what the hacking incident was.
It was criminal hacking for commercial purposes.
For a corporation, yeah. But that is unusual. The United States announced or declared that it believed North Korea was responsible for the Sony hack and the damage that was caused as a consequence of that. And I'm really confident that you wouldn't do that unless you had some really good grounds for that. And in Australia's case, you can understand the reticence for naming particular countries until we're really confident that it was a state-based responsibility rather than an individual group of hacktivists that were coordinating together.
Up the back there. And then you, sir.
Thanks very much. Matt Sussex, National Security College at the ANU. I was just wondering, question broadly for the panel, given that cyber norms are pretty much in their infancy and the kind of burden tends to fall on the international community in a way that they find it very difficult to respond to cyber attacks, either as a collective or as individual states. You tend to think that it tends to favour the offensive in cyberspace. So I'm just wondering how specifically you think that Tallinn 2.0 might contribute towards deterrence and perhaps more generally as well. Thanks.
Interesting question.
You want to go first, Tim?
No, I'd like to hear what Mike has to say. Deterrence.
So I've known Tim for decades now. I'm glad some things never change.
Yeah, that's exactly right, mate.
So this is a really interesting question. When we started out, there was, many years ago, 7 years ago, there was a debate over whether international law even applied to cyber activities. So are there any norms at all? Are we drawing on a blank chalkboard? The Tallinn 1 group of experts quickly dispensed with that notion for a number of reasons. The primary reason being international law always applies to new activities unless you can make an argument that there's a reason it should not apply here. Why is this activity different than other activities? There are International Court of Justice cases on point and so forth. So we agreed that international law applied. The question was how does international law apply given the unique nature of cyberspace? But we were able to come up with 95 rules, and this time around we've got 154 rules. And so I'm not one of these people who suggest, for obvious reasons, that, norms are hard to find in cyberspace. On the contrary, norms are pretty easy to find in cyberspace. What I see on the part of states is states to some extent like strategic and operational level ambiguity because it gives them room to maneuver. So, when a legal advisor from a nation starts telling me the law isn't clear, I'm thinking to myself, that person simply doesn't want to look his boss in the eye, speak truth to power, and say, listen, boss, you can't do that. Or you can do that in some cases. So with respect to the Tallinn Manual, I've thought a little bit about this in light of activities that have happened. And I believe the Tallinn Manual will add to deterrence. And the reason I believe it will add to deterrence is clarity in international law violations and clarity with respect to the responses that are available to states will place those states that wish to operate in those allegedly ambiguous areas on notice that their activity may come with a potential cost. And to the extent that states know there's a potential cost, I think that's good. To the extent that states know there's a potential cost, it also diminishes the likelihood of escalation because it increases understanding among the players in a particular incident. So I'm hoping the Tallinn Manual contributes to both deterrence and diminishes the risk of escalation. I will tell you, I've been watching the Russians for a while, for a long while, because I used to be a nuclear targeting officer, and so for a long, long while, in a sort of different way.
Good clarification.
Yeah.
Down at Periscope for a while.
So I believe the Russians have become absolute masters in engaging what I've been calling asymmetrical lawfare. Not warfare, lawfare. Because what the Russians do is they understand there are certain areas of operations where at least there's an appearance of a lack of clarity that allows them room to maneuver. And when other states go to react to Russian activities, they're fumbling around because they can't get a clear fix on whether the Russian activities were unlawful or not. I mean, we certainly saw this with the DNC hack. We saw it even more clearly with the Russian invasion and occupation of the Ukraine. I mean, let's not forget that no matter how it's played out by whatever administration, the Russians are currently in belligerent occupation of the Ukraine, and Russia and the Ukraine are in a state of war, what a lawyer would call international armed conflict. But because they're playing in this gray area, it's hard to pin the rose on them, and they will do so in cyberspace. And so the answer is we will help the process, the Tallinn Manual will help the process, but the real responsibility lies on states, because the fact that 19 academics from around the world came together and agreed on this or that is persuasive but not dispositive. It is only when states, develop the courage to say, this is our red line, and other states agree with that, that will achieve clarity. And until that point, states that want to abuse cyberspace, like Russia, the states that want to abuse cyberspace will continue to do so. And you know the old rule, if you don't discipline your child the first time they do something, they learn bad habits. And right now, states like Russia are learning very bad habits. But I don't feel strongly about this one way or another.
An excellent answer. Pin the rose on, is that the Yellow Roses, Texas, your home state? Is that what you're talking about? These colloquial expressions. We include a chapter in Tallinn 2.0 on espionage and international law in relation to espionage in the cyber context. And we agreed as a group of experts that espionage is not a violation of international law per se. It depends how you conduct the espionage and what you actually do with the information that you might acquire. And perhaps one of the interesting things about cyber espionage, which obviously happening on a daily basis, is that there are ways of finding out when it's happened, when data has been stolen or systems have been hacked into, in ways that in conventional espionage we might not have discovered that the espionage had gone on. So that could be an interesting aspect of how states respond to the concept of espionage, but we were very clear about the fact that it will depend on how the espionage conduct occurs, in what context, and what happens with the material that's gained, whether or not a violation of international law occurs. And I'm with Mike, I guess. I think that the huge benefit of Tallinn 2.0 is not to determine the law. We can't do that as academic experts, but to bring some focus and clarity to it, which has drawn the attention of the international community, has to be a positive contribution.
Yep. So let me just follow up a little bit, since the, I guess, 1 million Tallinn manuals that are on their way on some boat to Australia haven't arrived. Let me explain a little bit about how we did the manual, because I think it's important for states to understand how the manual is crafted. We have, as Lee said, we have black letter rules that represent unanimity, but of course unanimity is hard to achieve, particularly given the nature of the group. It came from all over the world. All of us, I will say, every single, I think to a person, Timbo, every person was committed to an objective analysis of the law.
Yeah.
No one came wearing their flag. Tim was not an Australian, and I was only a Texan in terms of running the group, but not in terms of my legal approach. But so even in that group, it became hard to achieve consensus. However, to the extent that the international group of experts achieved consensus, states need to understand that if they are going to adopt a legal policy contrary to that, it's going to be a really hard sell. That doesn't mean that states shouldn't do that. States should make up their own, they should make their own legal policy decisions based on their national interest and what they truly believe the law to be, but it's going to be a really hard sell. And it will also be an easy sell when you want to condemn other states for violating a particular norm that all the experts agreed on. But the really valuable part of the book isn't where we achieved consensus. In many, many, many occasions, we did not achieve consensus. So what we tried to do is, in some cases, we say the majority said X, the minority said Y. Some cases we are split down the middle and we say so. Some cases, almost everyone said X, but a couple of people said Y, and we acknowledged that. And in some cases, when we went to The Hague on the 3 meetings with states, sometimes states made an assertion that we thought was wrong, but it was reasonable. It's just that, okay, reasonable people differ with respect to the law, and so although none of these 19 people, or apparently none of these other folks in the room believe that's the law, that state believes that is in fact the law. I'll give you an example. One state believes there is sovereignty over data no matter where it is. That's just one example. We didn't buy that. And so the real value of the manual is in the disagreement, because it tells states where they need to begin to focus their effort. It tells states where the gray area lies within which other states will intentionally operate. It tells states where they need to seek clarity and consensus. So we talk about, the ambassador talked about the global commission. Of course, you have the UNGGE and so forth. I mean, if I were sitting there, I would think of the manuals manna from heaven, not because they've given us answers, although I'd like to think we have in some cases, but because they've mapped out the road we must follow as we try to ascertain how international law applies to this rather unique domain of state engagement.
So before we move on to the next question, I'll just ask a follow-up of you both. So would it be fair to say your view, and you may have different views, is that the way we're going to achieve this clarity is just by a patchwork of mishmash of incidents and statements of policy? There's not going to be any really successful push for some sort of baseline instrument in this field. Is that a fair assessment?
I don't think there will be any push for a new treaty or protocol in the short term, but it may be that in a few years' time, with more state practice in response to cyber operations directed against the state broadly defined, whether it's government or private enterprise, that there might be a desire then to bring some clarification, particularly around what permissible reactions the law might allow. But I think it's probably, I don't hear any calls for that right now. So I suspect that that's a few years down the track.
Yeah.
So the notion of a treaty is forget it. It ain't going to happen. So move on. And the reason...
Not that you've got any firm views about
I
that.
and there's a reason for that. Again, to repeat what I said earlier, what you see depends on where you stand, and different states are dissimilarly situated with respect to cyber activities. Some states are potential offensive operators. Some states aren't. Some states are more likely to be victimized in cyberspace than other states, and then there are lots of other concerns. And then even within governments has suggested, perhaps by the DOD letter that I mentioned, even within governments there is going to be disagreement upon what a nation's legal policy should be. So you've got to get the state to agree, and then you've got to get states to agree to a treaty. So I'm less than pessimistic on this front. That doesn't mean that states can't begin to do norm building consensus. So you have the initiative based in The Hague, led by the former Foreign Minister of Estonia, and she's a world-class expert in the field of norm development. I can see norms development. So, and we've seen that to some extent. For example, due diligence. So Lise Vihol was our initial due diligence person. We all agreed with the analysis that she came up with, that due diligence was in fact a legal obligation. Now, the principle of due diligence was considered by the UNGGE. And in the UNGGE statement, Lisa was 2015 statement or 2015 statement, it says states should, and I'm paraphrasing, should take action to put an end to harmful activities from their states. Well, I happen to believe the answer is states must. It's not should. It's a legal requirement. But we'll see. That's nevertheless a big step forward. However, I believe the progress will come with respect to states. Again, I don't mean to pick on the Netherlands, but the Netherlands is a leader in this regard. They commissioned a report of experts. One of our experts, Terry Gill, from the University of Amsterdam, was a key player in this, called the AIVCCV. It's an abbreviation thing. But at any rate, the government adopted this, and the statement was added a great deal of clarity on what the Dutch government believed their position was, for example, with respect to an armed attack or use of force. In our country, Harold Coe, as the former legal advisor at State, made a number of important speeches setting forth the U.S. position. So I think most of the play will come, in terms of law, will come with regard to states acting unilaterally, albeit in cooperation with other like-minded states, to set forth their national position on the gray area. But again, you know, it's going to require states to not only in statements by governments and speeches, it's going to require them to step up and begin to have the courage to say, not only this is our position, but when something happens, say, listen, you can't do that, and the reason you can't do that is because that's a violation of international law. But I think that states, a number of states, Estonia, the Netherlands, the United States, are starting to move in the direction of making such statements and naming and shaming violations of international law.
Oh, sir, your question. Just get the microphone.
Thank you. I'm Abbas from Afghanistan Embassy. So it seems that it's mostly focused on interstate cyber contention. But if put it in a little bit complicated scenario, for example, there is country A, state A, and state B in the context of counterterrorism. And the terrorist organizations have sanctuaries in state A and launching cyber attacks against state B. So in that case, what is its implication, the international law implication, and what says Tallinn Manual 2 about international law implication on state A that provides sanctuaries and not necessarily direct action from the state A against state B, but the sanctuaries is provided for terrorist organizations attacking against state B. And what's this implication in that context, more complicated context than that normal state-centric approach? Thank you very much.
Mike, we might go to you first because that was an issue you did deal with to an extent in Tallinn 1 and Tallinn 2.
So to answer your question, you have to ask how severe are the operations being launched by the terrorist from the sanctuary state. If those operations are destructive or injurious, they are probably at the armed attack level, thereby giving the victim state the right of self-defense. And I mean self-defense not only in the cyber context, but self-defense in the kinetic conference. So the victim state then would be obligated to ask the territorial state, the state where the terrorists are, to get to cause the terrorists to stop their activity, because that state's sovereign. So you have to first ask them if it's reasonable in the circumstance to ask them. So you say, this is happening, make them stop. And if that state cannot or will not make them stop, that state can't take away your right of self-defense, so then you may act. This is exactly the same analysis used for example, drone strikes against terrorists in ungoverned states or states that either harbor terrorists or don't have the ability to put an end to terrorism. So exactly the same analysis that a number of states have expressly embraced.
Or the US operation in Afghanistan in October 2001. They asked Afghanistan, the Taliban in power, to hand over Osama bin Laden. They refused. They said, you're harbouring the person responsible for 9/11. We will now attack the country.
In self-defense.
In self-defense.
That's exactly
Not
right.
in cyber context, of course, but in the kinetic
But the analysis, the
legal
analysis tracks. Now, the harder question is, what if the terrorist, or let's say they're not terrorists, they're a malicious hacker group or something, bad guys, okay? What if the bad guys are conducting operations from one state into another state? Well, this is a bit more problematic because we would normally think of, taking us back to the first question, countermeasures. Want to hack back or do something like that. You obviously can't drop a bomb on them. So but you want to hack back, you want to conduct active defense operations against them. The problem is that the law of countermeasures does not permit countermeasures against non-state actors. It only permits countermeasures against states. And so what you have to do in order to conduct your operation is you have to find a breach of international law by the territorial state, the state where they're located. The breach that you're most likely to find happens to be the breach of the due diligence principle. Because remember, as I said earlier, that state has an obligation to put an end to harmful activities. So what you do is you say to that state, the sanctuary state, you are in breach of your due diligence obligation. Comply with it. And if that state chooses not to comply with that obligation by putting an end to the terrorist/hacker operations, then the victim state may now take countermeasures against the sanctuary state, not because of the terrorist activity, but because of the breach of the due diligence obligation. And what form would those countermeasures take? They would be cyber operations that would likely violate the sovereignty of the territorial state by directing them against the terrorist group. So they're technically countermeasures against the sanctuary state, the territorial state, but those countermeasures take the form of actions against the terrorist group. That's a very, very interesting and perceptive question. Because as I mentioned, when we took the principle of due diligence forward to states, they freaked out. You know, it's like, holy cow, you mean we have this obligation, oh my God, and we said, calm down, drink a glass of calm down. Let us explain. It's only feasible, it's only reasonable, it's only serious adverse. But then we said to a number of states who have capabilities, you sure you want to oppose this? Because the due diligence principle gives you a perfectly legal way to put an end to harmful activities emanating from another state that are not at the armed attack level. And once they figured that out, much of the concern over due diligence faded away because it gave them legal justification for action against non-state actors that were not, you know, destroying nuclear reactors, for example.
Yeah, can't resist this. Only one state said, oh my God, holy cow. The others
Don't reveal, you're
the
not
other-
supposed to reveal the state.
The,
You're not supposed
the
to
others
reveal
said
the
other
state.
things. You're a classic, mate. But just one clarification on the law of countermeasures. Not only can countermeasures only be directed against a state, but they can only be undertaken by a state.
Right.
So we, in international law, do not allow a non-state entity, whether that's a corporation or whatever else, to undertake its own countermeasures. So perhaps one of the contributions that Tallinn 2.0 will make is a more engaged and open discussion at the national level between those non-state entities that are the subject of cyber operations themselves and the state authorities that are taking responsibility for cyber security, cyber defence, and possibly countermeasures in response to cyber operations.
Yeah, I mean, we've on a couple occasions, we've met with the private sector, conferences and so forth. And, you know, the private sector seems to think, you know, like, hey, they're doing it to me, I can do it back to them. And they seem to think, well, it's like self-defense. I'm walking through the streets of Canberra, some crazy Australian attacks me, I can defend myself. It's not exactly like that. And so what the presentations on the Tallinn Manual have done for the private sector is woken them up to the need to collaborate with states, because one thing a state can do, only a state can take countermeasures, but they can outsource the countermeasures. So a state could say to the private entity, go ahead and take responsive operations, but when it does so, that operation takes on the legal character of an act of the state which gave them the green light. So at least in the United States, some of the players in the private sector are now saying we need to sit down with states and fashion out rules of engagement. We need to develop mechanisms for speeding up the process of either getting states to respond or being authorized by a state to act on behalf of the state, and so forth. So I think that has been a positive development. The fact that we said you can't do that has had positive results, at least in my country.
Question in the front row here. Microphone.
Thanks very much, particularly on that conversation on non-state actors. My name is Gabe Brotman. I'm the Shadow Assistant Minister for Cybersecurity and Defence. And my question is to you, Tim. In the work that you did on the manual, did it expose any gaps in Australian legislation or Australian regulation or rules or norms? I'm looking at it from a public policy developer perspective.
Sure.
And I'm also interested, you highlighted the fact that the best part of developing the manual was, in a way, those areas of disagreement. So I'm interested in what your areas of disagreement were.
Yeah. Thanks, Gabe. 3 of the 4 meetings that I attended in Tallinn I did from the US because I was in Newport, Rhode Island, and I wasn't thinking too much about Australian legislation or even about Australian government policy in relation to cyber security and cyber defence. So now I'm back from the US, snuck out before the election. I lived there through the primary process. That was a fascinating experience. But now that I'm here,
Not the right adjective.
okay, sorry, possibly not the right comment either, or even the right allusion. But now that I'm back, I would actually really like to engage with some of those responsible for these sorts of questions and try to work out where some of the gaps are. I know that, there was a fascinating conversation going on in the United States in response to the Sony hack in particular, less so to the OPM hack because that was government entity. But in relation to critical infrastructure where so much has been privatised, are government authorities actually taking responsibility for cyber security and cyber defence of critical infrastructure? Or is there an issue about leaving that to the privatised entities? And I think that's potentially that's a huge issue and a really important one to ask. And I haven't had those conversations in Australia, but I'd like to be confident that people are talking about it. And I don't want to, communicate that I don't think that's happening. I hope it is. I just don't know. So yeah, I'm open to some new discussions here. In relation to some of the controversies myself, I know we talked a lot about data and data as an object, and I was not involved in Tallinn 1.0, and Ryan, my colleague, and my Estonian colleague who I mentioned before, he and I, we engaged in some of our own observations about Tallinn 1.0 and some criticism about the approach that was taken in relation to that question. And in Tallinn 2.0, when we visited it, I saw how sensitive it really was. And our Chinese colleague, a wonderful member of the international group of experts, had some very firm views about data as objects, and I suspect that we will see an ongoing debate about that question and how international law characterises data and sensitivities about it being stolen and what the implications that should be. There were lots of things that we had pretty robust discussions about, but I think one of the joys of the process was the opportunity and the privilege to do that, to really engage in robust discussion about our views about particular rules of international law and how they might apply in the cyber context. And I think we've done, as Mike explained, a very good job in the manual of reflecting disagreements in relation to some interpretations of rules of international law or some views about how those rules might apply to cyber operations.
Indeed. Mr. Brotman's question takes us right to the heart of the issue, and I guess, Mike, you might follow up on this as well. There is an area of overlap, isn't there, yet that's perhaps not fully explored, of where the cyber operations as a matter of national security and international law overlaps with cyber operations as a matter of criminal law and as a matter of transnational organised crime, and that there is clearly an overlap there, and that some of the actors are the same actors, some of the means and methods are the same means and methods.
Some of the victims are the same victims.
Some of the victims are exactly the same victims, exactly.
Well, we deal extensively with non-state actors throughout the manual, although we do deal with them in the context of international law. But there are a number of clear areas of overlap, and two come to mind right away. The first is espionage. Espionage, as Tim mentioned just a moment ago, is not a violation of international law. It's a violation of domestic law. Now, espionage may be carried out in a way that violates international law. For example, when we were looking for an example, one of the people with some experience said, listen, when I'm conducting espionage into cyber infrastructure, what I may want to do is cause physical damage to the cyber infrastructure so that the other side, the target of the espionage, is unaware that I've exfiltrated data and just thinks something went wrong. Okay? Well, that isn't unlawful because it's espionage, but it very well may be unlawful as a violation of the sovereignty of the state. But the example that comes to mind right away in the espionage context would be the DNC hacks. So in the DNC hacks, you had an example of espionage against the Democratic National Committee and others that had pretty, in my view, a significant impact on not only the presidential race, but also some congressional races. A member of the Democratic National Committee chairman resigned during the midst of an election, et cetera, et cetera, et cetera. In that case, there was a violation of U.S. domestic law. And so when we were, when trying to, not the group, because this came after when I was thinking about intervention requires, and I'll use legal terminology here, an act with respect to the domaine reservé, meaning the area of activity that is reserved specifically to a country and not to the international arena. That would be elections. It's the example we used even before the DNC hack.
Indeed.
It was the classic example, but that must be coercive. And by and I use that in a legal term, a legal sense. Coercive means you make a state do something it would otherwise not do, or you cause it to refrain from an action it would otherwise take. In this case, the question is, did the activities, were they intended to cause the election of someone other than the person that would have been elected? Now, Lise and I have a running battle on this. I think she's one of the smartest people in the world on cyber, so I hesitate to disagree with her for that reason and many other reasons.
But you will.
But I will on this case. So Lisa's argument, and I'll paraphrase it, and it's a really, really good argument, is that there was no intervention because espionage is not unlawful. Okay, it was in domaine reservé, but it's not unlawful, and it wasn't coercive because all that was done was the release of factual material, and in a democracy, goodness gracious, factual information is good. More information is better, so you have a better informed electorate. In my view, and so she says it's not intervention, and that's a perfectly reasonable view. My view is that it just tripped over the line of intervention and was rendered unlawful. Why? In great part because of the way in which it was carried out. It was carried out by engaging in an activity that was not only a violation of U.S. law, but would be a violation of the law of many, many, many other countries. So it's not the Americans have some weird law. It's that, well, that'd be the law here in Australia, I assume, as well, or in Belgium, or in Bolivia. And that meant that the process of electing someone, of more than one person, was distorted. It wasn't so much the release of the factual information as a relevant criterion, it was the distortion of the process by means that would be criminal in the law of it was criminal in the law of the United States and would so be in Australia as well. So getting back to your original question, I think there's enormous value in looking at these international rules and saying, where can domestic law contribute to clarifying? And I'll give you one other example. I'm aware, Rob, that we're a little over, so I'll make it short. Our president has designated, as you know, surely, election cyber infrastructure, the machinery that runs elections has critical infrastructure. He's so designated, or not our president, the last president. He who is good. So you need to turn off the camera.
You're from Texas.
But that's why I live in Rhode Island now. Okay, but soon I'll be able to go back. So does that have international legal significance? No. Just because a state says something is critical infrastructure does not. But there is a rule regarding responses called that deals with what's called the plea of necessity. We talked about countermeasures. This is a different sort of response, and the response goes like this, and I'm abbreviating. When a state's essential interests are affected in a grave and imminent way, then the state may take those steps that are necessary to put an end to it, even if it lacks attribution, or even if it's a non-state actor and therefore countermeasures are not necessary, and even if the actions of a state will affect the interest of other states. So this is very important because you may have an operation that is affecting your essential interest and you don't have the attribution piece of the puzzle. So you don't know if you can shoot back, if you will, in cyberspace or not. The designation by a state of critical infrastructure that is matched by the designation of similar cyber infrastructure in other countries begins to build an international community and international law consensus as to what not critical infrastructure is, but as to what an essential interest is as a matter of law, thus opening the door to a robust response in a situation that is very, very critical, but you don't know who did it. And so we haven't thought through, to be very frank, the international law, domestic law implications. And I really think it would be useful to get international lawyers like the three of us there and domestic lawyers to just walk through the international law and seeing are there pieces of the puzzle that we can assist each other on. By the way, it's not one way. It's not just you guys firming up international law. It's us providing you a basis for domestic legislation. And I think, like, as I said, a lot of work needs to be done in the private-public sector, but a lot of work needs to be done among international lawyers who operate in various areas, domestic and international. And with that, I will be quiet. Okay.
Well, ladies and gentlemen, we've run out of time, I'm afraid. We could keep going, I've no doubt. But we do have some time for some other sidebar discussions at morning tea. Just prior to handing over to Liam to wrap things up, can I just say on behalf of the panel and myself, our deep thanks to the Embassy of the Netherlands and to the Centre and to ASPI for hosting us today. And Mike also asked me to send a big hello out to his rather large fan base in the Russian government who are listening in by the projector there. So hello to them as well. Liam, over to you.
Spasibo большое.
Thanks, Rob. Conscious that I'm now standing between you and food, I will wrap up very quickly. So, ladies and gentlemen, can you please join me in again thanking our expert panel. Thank you.